Hello viewers, in the last session we discussed majority powers, minority rights, oppression and mismanagement. In this session we are going to discuss compromises, arrangements and amalgamation. The objectives of this lesson is to explain the compromise, arrangement and merger of companies including cross-border mergers. A person can do business in any of the following ways: sole trading concern, partnership firm and it is regulated by Partnership Act 1932, company form of business and it is regulated by Companies Act 2013, limited liability partnership and it is regulated by Limited Liability Partnership Act 2000, joint Hindu family business and it is regulated by Hindu personal law. Laws applicable to mergers: Companies Act 2013, sections 470, chapter 15, compromise, arrangements and amalgamations, sections 230 to 240, Foreign Exchange Management Act 2000, Takeover Code 2011, Competition Act 2002. Reconstruction. Reconstruction of a company implies reconstitution of company's financial structure with or without its dissolution. It may include the reduction of claims of both the shareholders and the creditors against the company. The underlying objects of reconstruction may be simplification of capital structure, reduction of fixed charges, elimination of past losses, adjustment of arrears of cumulative dividends, rising of company's working capital. Thus, a reconstruction generally becomes necessary on account of deterioration in the financial position of the company. It may be of two types, namely external reconstruction, internal reconstruction. External reconstruction. In case of external reconstruction, the existing company dissolves and a new company is formed to take over the business of the existing company which is in bad financial position. The vendor company goes into liquidation after selling its business to the new company. Such a transfer of business has two effects, namely acquisition of the transferred assets and liabilities by the transferee company and disposition thereof by the transferor company. Accordingly, the transferee company passes the formation, acquisition entries and the transferor company records the dissolution, disposition entries. Internal reconstruction includes both alteration and reduction of share capital. The alteration of capital may be affected by increase of share capital by issue of new shares, consolidation or subdivision of the existing shares into shares of larger or smaller denominations, conversion of fully paid shares into stock and vice versa, cancellation of unissued shares. Internal reconstruction. In case of internal reconstruction, the capital structure of the company is reorganized to infuse new life in the company. It permits the continuance of the existing company and therefore involves no creation or dissolution whatsoever. It simply reorganizes the company's existing financial structure without affecting any transfer of business. On the other hand, reduction of capital may be caused by writing off lost capital, refund of surplus paid up capital, reducing liability of members for uncalled capital. Chapter 15, titled Compromises, Arrangements and Amalgamations, deal with mergers. Sections 230 to 240 deal with mergers. Section 390 to 396A of the Companies Act 1956. Section 230. Power to compromise or make arrangements with creditors and members. Old sections, Section 390, 391, 393 and 394A of the old Act. The term compromise presupposes existence of some kind of dispute, such as one relating to rights of creditors or members of the company. In other words, there can be no compromise without the existence of a dispute. Smith vs. Valley Gold Limited, 1893, 1 Chancery 477. Section 230 of the Act empowers the company to settle its disputes with its creditors and members by compromise without going to any arbitration for this purpose. On the other hand, Section 230, subsection 1 provides for arrangements which for the purpose of this section means reorganization of the share capital of the company by consolidation of shares of different classes or by division of shares into shares of different value or by both these methods. Hindustan Commercial Bank vs. Hindustan General Electric Corporation, AER 1960, Calcutta 637. Thus, the term arrangement has a much wider connotation than compromise, as it includes rearrangement of rights and liabilities of shareholders and the company without existence of any dispute. A scheme of arrangement modifying the rights of shareholders can be brought out under Section 230, subsection 1 of Companies Act 2013. Section 230, subsection 1 of the Act provides that provisions of Section 332 and 333 regulating the matters relating to compromises, arrangement and reconstruction, amalgamation, etc. apply to companies which are liable to be wound up. The application under Section 230, subsection 1 of 2013 Act for compromise or arrangement can be made not only by the liquidator of the company which is in liquidation, but also by any of its creditors or its members. Some of the factors which may call for a compromise with creditors or members of the company may be: in the course of normal working of the company, it is no longer possible to pay all the creditors in full. Some of the units of the company cannot function without incurring losses. There may be need to compromise debts outstanding to the creditors, government or the workers. Liquidation of the company may prove harsh on creditors or members of the company. The scheme of arrangement may be necessary in the following cases: reorganizing the share capital of the company, fresh issue of shares, issue of shares to creditors in lieu of debt, sale, lease or other variations in property rights, conversion of one class of shares into another, etc. Procedure for the scheme of compromise and arrangement. Section 230 of the Act also lays down the procedure for making compromise or arrangement and for invoking the assistance of the tribunal for this purpose. Where it is proposed to make a compromise or arrangement, a company, a member or a creditor of the company or the company which is being wound up, the liquidator shall make an application to the NCLT proposing a compromise or arrangement between them and the company, seeking directions of the NCLT to convene a meeting of each class of creditors members. After the NCLT gives any directions, the meeting of the creditors and or members affected shall be convened. When the scheme proposed is between the company and its members, it is not mandatory to hold the meeting of the creditors. However, if the NCLT feels that the scheme is likely to adversely affect the creditors, it may direct a meeting of the creditors also to be held. Approval of the scheme through postal ballot is valid under the Act. The Act now mandates annexing of the valuation report to the notices for the meetings to enable ready access to the shareholders and creditors. Section 232, subsection 2. Objections can be raised by shareholders holding 10% or more equity and creditors whose debt represents 5% or more of the total debt as per the last audited financial statements. Auditor's certificate stating that the accounting treatment is in accordance with the accounting standards was required to be filed for seeking approval of the stock exchanges by both the listed and unlisted companies. Merger of a listed company into an unlisted company. Notice of the meetings. Section 230, subsection 5 of the Act obligates companies to send a notice of meeting to approve a merger to various government authorities such as central government, the income tax authorities, SEBI, RBI, ROC, the respective stock exchanges, the official liquidator, the Competition Commission of India, any other regulated authority likely to be affected by the merger. Section 231, sanction of the NCLT. Before passing the order, the NCLT should satisfy that the company or any other person by whom the application is made has disclosed to the NCLT by affidavit all the material facts such as the financial position of the company, the latest auditor's report. The relevant statutory provisions of the Act have been duly complied with. Class or classes of creditors, members, etc. affected by the scheme have been fairly represented, and the arrangement is such that a man of business would reasonably approve it. The NCLT would not sanction the scheme of compromise or arrangement if it finds that there was no approval by the appropriate class as it had not been properly represented. Powers of the NCLT. Section 231 confers wide powers on NCLT relating to sanctioning or rejecting the scheme of compromise or arrangement. After sanctioning the scheme, the NCLT has power to A. Supervise the carrying out the compromise or arrangement, to modify the scheme for its proper working, to order winding up of the company if it is satisfied that the scheme of compromise or arrangement is not workable. The NCLT cannot sanction any compromise or arrangement unless it is satisfied that the company or any other person by whom an application has been made has disclosed to the NCLT by an affidavit or otherwise all material facts relating to the company. Section 232. Merger or amalgamation of companies. Section 232 of the Act provides that where an application under Section 230 for compromise or arrangement is made for the purpose of reconstruction of a company or for amalgamation of two or more companies, and the whole or part of the undertaking, property or liability of one company, transfer or company is to be transferred to another company, transferee company, the NCLT may, in sanctioning the scheme or by a subsequent order, provide for all or any of the following matters. A. The transfer to the transferee company of the whole or any part of the undertaking, property or liabilities of the transferor company. B. The allotment or appropriation by the transferee company of any shares, debentures or other like interests which have to be allotted or appropriated under contract. C. The continuation by or against the transferee company of any legal proceedings pending by or against any transferor company. D. The dissolution without winding up of the transferor company. E. The provision to be made for any persons who dissent from the scheme. And F. Such other incidental, consequential or supplemental matters as may be necessary to secure the reconstruction or amalgamation is fully and effectively carried out. The proviso to section 232 subsection 3 provides that the NCLT has no jurisdiction to sanction a compromise or arrangement involving a scheme for the amalgamation of a company which is being wound up with any other company or companies unless it has received a report from the ROC that the affairs of the company have not been conducted in a manner prejudicial to the interest of its members or to the public interest. Another proviso to section 232 lays down that the NCLT from ordering dissolution of the transferor company unless the official liquidator has made a similar report after scrutinizing books and papers etc. in respect of the company. The report of the official liquidator is necessary only in cases when the transferor company is in the process of winding up. Otherwise, a report of ROC is sufficient for NCLT to sanction the scheme of amalgamation. Section 232 subsection 8 of the Act requires that within 30 days after making of an order by the NCLT sanctioning amalgamation, every company in relation to which the order is made shall file certified copy of the order with ROC. In case of default, the company and every officer who is in default shall be punishable with imprisonment for a term which may extend to 1 year or with fine which shall not be less than 1 lakh rupees but which may extend to 3 lakh rupees or with both. Section 232 expressly provides that in this section, transferee company does not include any company other than a company within the meaning of the Companies Act 2013, but a transferor company includes any body corporate, whether a company within the meaning of the Act or not. Section 233. Merger or amalgamation of certain companies, small and holding and subsidiary companies. This provision is meant to facilitate a scheme of merger or amalgamation between two or more small companies or between a holding company and its wholly owned subsidiary or such other class or class of companies as may be prescribed. The facility is subject to the following requirements. A notice of the proposed scheme inviting objections, if any, from the ROC and official liquidator of the places where the registered offices of the companies are situated or persons affected by the scheme within 30 days is issued by the transferor company or companies and the transferee company. Objections and rejections received are considered by the companies in their respective general meetings and the scheme is approved by holders of 90% of the total number of shares. Each of the companies involved in the merger has filed a declaration of solvency in the prescribed form with the ROC of the place where the registered office of the company is situated. The scheme is approved by a majority representing 9/10 in value of the creditors or class of them of respective companies at a meeting convened by the company by giving notice of 21 days along with the scheme to its creditors. The scheme may also be otherwise approved in writing by the requisite number. The transferee company has to file a copy of the scheme so approved with the central government, ROC and official liquidator of the place where the registered office of the company is situated. If the ROC and OL have no objections, the central government has to register the scheme and issue a confirmation letter to companies. If they have any objections and suggestions, they should communicate the same to the central government within 30 days. No communication from their side will create a presumption that they have nothing to say against the scheme. If after receiving objections or suggestions, the central government is of opinion that scheme is not in public interest or interest of creditors, it may file an application before the NCLT within 60 days of receipt of the scheme stating its objections and requesting that the NCLT may consider the scheme under section 232. Any other person affected can also make such application. The NCLT may confirm the scheme or order that it would have to be examined by following the procedure of section 232. If the scheme is confirmed, a copy of the order has to be communicated to the ROC having jurisdiction over the transferee company and persons concerned. The ROC has to register the scheme and issue his confirmation to the companies. Such confirmation also has to be communicated to the ROC where the transferor company or companies were situated. Registration of the scheme by the central government under section 233 subsection 2 and subsection 3 is to have effect of dissolution of the transferor company without the process of winding up. Registration of the scheme is also to have the following effects: transfer of the property or liabilities of the transferor company to the transferee company so that the property becomes the property of the transferee company and liabilities also become its liabilities. The charges, if any, on the property of the transferor company are to be applicable and enforceable as if they were on the property of the transferee company. Legal proceedings by or against the transferor company pending before any court of law are to be continued by or against the transferee company. Where the scheme provides for purchase of shares held by dissenting shareholders or settlement of debt due to dissenting creditors, the amounts become liability of the transferee company. After the merger, the transferee company is not directly or indirectly to hold any shares in its own name or in the name of any trust, either on its behalf or on behalf of any of its subsidiary or associate company. The transferee company has to file an application with the ROC along with the scheme registered indicating the revised authorized capital and pay the prescribed fees due on revised capital. Section 234, Merger of a company with a foreign company. The provisions of Chapter 15 with sections running from section 230 to 240 are to apply mutatis mutandis to schemes of merger and amalgamations between companies registered under the Act and companies incorporated in jurisdiction of such countries as may be notified from time to time by the central government. The central government may make rules in consultation with the RBI in connection with mergers and amalgamations provided under the section. A foreign company may, with the approval of RBI, merge into a company registered under the Act or vice versa. The terms and conditions of such merger may provide for payment of consideration to the shareholders of merging company. The expression foreign company means any company or body corporate incorporated outside India, whether having a place of business in India or not. After going through this lesson, the viewer will come to know the concepts of compromise, arrangement and different kinds of merger. I hope you enjoy this session and we will meet in the next session. Thank you one and all.